To continue with this agenda, now we have JaxBO Davidson from the Corps of Engineers. He's going to talk about artificial reef regulatory process and guidance for permit application submittals. So, Bob, thanks for being here today with us. Here you change the slide, so here's the pointer. Okay. I'm just going to put yours.
Well, good morning, everybody. My name is Bo Davidson. I'm a biologist and project manager attached to the Tampa permit section. I'm actually stationed in Gainesville. I'm the artificial reef subject matter expert for the West Branch permitting section of the Jacksonville district. And what they've asked me to do here today is give a presentation about essentially how to obtain a permit from the Army Corps of Engineers for an artificial reef. There's a pile of information here. I don't even know all of it. I do it for a living. So in the time that I have, I'm going to just be able to do a brief overview for you. And hopefully at the end, we'll have some time for questions. If you have any more questions, just seek me out at lunch or during one of the breaks, and they're going to put the PowerPoint presentation up. Feel free to contact me anytime, and I'll help you the best I can. What we're going to do here today, I'm just going to go over briefly the Corps' authority, how we ended up in the regulatory business for artificial reefs. One of the primary things the Corps looks at is considerations for proper reef siting, differentiate a little bit between what the Corps will permit as acceptable materials versus unacceptable materials, and discuss some other permit considerations related to Reef Design, Endangered Species Act, consultation and compliance and enforcement issues we see after the permits are issued for artificial reefs. Basically, one thing I just want to get out of the way up front is our artificial reefs in Jacksonville district are processed as standard permits. That's the most complicated permit process we have. So probably one of the biggest take-home messages to give you here today is to give yourself about a year to secure a Corps permit. A lot of times we get them out faster than that, but as you'll see going through this, I don't have control over a lot of what our sister resource agencies say, do, or comment about your applications, and it can take time to work through that process. Just a brief overview of the authorities involved. The Outer Continental Shelf Lands Act extended Army Corps of Engineers jurisdiction under Section 10 of the Rivers and Harbors Act out to 200 nautical miles or the extent of the EEZ. So basically, structures on the seafloor out to 200 nautical miles, which include artificial reefs, would require a Corps permit. There's not too many regulators that issue artificial reef permits because we've got a whole section of our Code of Federal Regulations dedicated to permitting them. This is one of the permit considerations to consider, is that if your permit or your application is for a reef that lies within state waters, likely your state permit is going to cover the requirements of the Coastal Zone Management Act. Essentially, what it says is that either an applicant for a federal permit or a federal project has to be consistent with the Coastal Zone Management Plan in the state. What does this translate over to for artificial reef permitting? Is if you're in state waters and you're going to get your state permit is likely going to constitute your CZMA consistency determination. If you're going to be in federal waters alone and there won't be a state permit issued, the Corps unilaterally has to work with the state clearinghouse to obtain your consistency determination. The take-home message here is that's about a 60-day process. So back to getting enough time to secure your permit and on time to get your funding and do your deployment. That's an example of a time sink that I have no control over. It's controlled by statute. I can't make it any faster unless the state clearinghouse decides to move along quicker based on their time frame. One of the questions here today was who's liable for these things when they go wrong. It's Jacksonville district policy that it's generally a government or state entity that's self-insuring and covered under sovereign immunity. We've had a couple instances where individuals or groups have tried to self-insure for artificial reef purposes. And as they've gone through our Office of Counsel, the bonding would have been in the millions and the project was not viable. So Jacksonville District policy is that it's a government entity or a county. I've worked on permits where there's been co-applicants. The county's been the primary applicant with a secondary applicant in the wings. But that's just one thing to consider. I think we all know the benefits of artificial reefs here or why you would seek a permit for one. Probably one of the biggest take-home messages there is that the artificial reef program that kind of really dragged the core into the permitting was the NEFA, the National Fisheries Enhancement Act of 1984. That act directed the Secretary of Commerce and NOAA to put together a national artificial reef plan. And these are the things it covers: guidelines for siting, material, some guidance on materials, criteria, how to coordinate state and federal stakeholders, and then, like I said, more guidelines for acceptable materials. Why this National Artificial Reef Plan is important: the Code of Federal Regulations, the core regulations require that we take this into consideration and the requirements of it before we make a permit decision. So generally, we're supposed to be consistent with the National Artificial Reef Plan. If something about an application or permit would not be, technically we're supposed to coordinate that with NOAA before we roll out. So it's just a document you would want to be aware of as you put your applications together. Considerations for siting. The gentleman from Volusia County hit the nail on the head. Your objectives of your reef, you would need to consider those. What's the appropriate location for the goal of your reef? Is it recreation, enhancement, or restoration, or a mitigative opportunity for an impact for another project? Your siting should be appropriate for the objective of the reef. Generally, what I see in the Gulf Coast and this kind of Big Bend region is to create some low relief or hard bottom habitat where none exists. We have a seagrass and a sand shelf and then an offshore community. A lot of these artificial reefs, the stated purpose is to introduce some fisheries habitat and that kind of netherworld of bare bottom between the two to pick up migratory species as they leave the coastal estuaries and migrate out to be deep water pelagics. Another siting criteria is protect existing resources. NIMS absolutely loses it if you're going to put any of your stuff near seagrass or existing resources. They get really picky about buffers. They get really picky about deployment techniques. So that's one thing to keep in mind. The more sand bottom, the better. In terms of putting together an application, one of the Corps' primary responsibilities is coordination with NOAA charting. Really the only way that an obstruction to navigation can become called a fish aggregation or fish attraction device or artificial reef on a NOAA chart is if you obtain your Corps permit. So one of the things that the Corps is responsible for in the permitting process is charting with NOAA. One of the things that I've seen in the last couple of years is point radius reefs, or NOAA is really discouraging those. They want to see square reefs with discrete corners and a central point. Make sure your coordinates for each corner are correct. One of the things that really ties up your Corps permitting is if NOAA comes back and says this reef is not where they say it is. I've had instances where we've had previous reefs permitted that don't lie where they say it lies. I think Ben Dixon was one. It was a nightmare to try to sort out where that thing actually was on the NOAA chart. So get that correct from the get-go. Another interesting thing to note is FWC uses a different coordinate type than the Corps. We like decimal degrees. I think FWC uses, Keith, is it degrees? Was it decimal degrees now? You standardize it?
No, it's like that's how.
Right. So a lot of times our public notice will contain both. But materials criteria, this is kind of something to stress. Keith talked about it a little bit, that a lot of these guidance documents were never intended to be regulatory documents. They weren't supposed to be documents that the Corps or regulatory agency was to latch onto and make it so that the only thing you could use was something in the book. So just to give a brief overview, the function, since NEFA says anything I permit has to have a fisheries enhancement goal, your material should be appropriate to function to stimulate some habitat growth. Its compatibility should minimize risks and user conflicts, either to navigation or, for example, if you're going to put out a dive reef and a diveable distance, diveable depth, don't have it full of rebar and things that would snag a diver. If you wouldn't want to dive on it, don't dump it. Stability, generally the guidelines for your reef modules and the like are stability in a 20-year storm event. Vessel deployments, we like to see 50 years per our guidance. And then durability, we don't want to see white goods put out. The tires was an example. You want things that are going to hold up long-term and be suitable to develop marine habitat. You don't want to dump trash out that's not going to create marine habitat. Conversely, you don't want something that's going to break down in a short number of years and not hit your stated reef goals. This is the infamous document that the Gulf Council put together. It's the guidelines for artificial reef materials. Where this matters, everyone says, like Keith mentioned, it's not a regulatory document, but the way I continually see applicants for artificial reef permits held to them is when the public notice goes out under the Madison-Stevens Fisheries Management and Conservation Act. National Marine Fisheries Service is to protect essential fish habitat. A lot of the essential fish habitat biologists, their conservation recommendations to the Corps is that the applicant follow these guidelines. It's very difficult for the Corps to walk back from a conservation recommendation from NIMS. We basically have to send them a letter that says why we're not going to do it within 10 days of issuing the permit. They can object, they can elevate it. So generally this is why applicants get stuck to these. Here's some of the acceptable material requirements they list. I'm not going to belabor those here. Basically heavy enough not to move and clean, and they're not going to snag. Some examples of acceptable materials, the prefabricated modules, concrete boulders, things we've seen here today that I think everyone here, I'm getting the impression, understands what the appropriate materials are and what are not. Some more examples. Like I said, but this is probably something to touch on if you want to deploy a vessel. Generally, they're steel, minimum 60 feet in length, and there's some other considerations there that would add time to your permitting. There's EPA and Coast Guard regulations for basically the reefing of one of these vessels. It's another criteria that we would have to satisfy in the permitting process, which takes time. One of the things I have seen is occasionally someone will add a vessel to drawings for an artificial reef permit, but I can't authorize the permit without the vessel specifics. So I think Bill Horn's here. I think I've had him pull vessels off of drawings more than once, just because without these criteria satisfied, I can't issue the permit. But we can authorize the site, and you can do the workup to show that it's an appropriate site for deployment. And I could always modify the permit should a vessel deployment opportunity arise. Here's another example of the Rigs to Reefs program. It's kind of similar to what you were talking about doing with the military bases, chopping the top of the tower off and leaving the unsalvageable parts behind for reefs. Some unacceptable materials, we've talked about them, white appliance goods, tires, entanglement hazards, things that fiberglass hulls are a no-no. They don't really last very long. They don't encrust much material, and we don't want entanglement hazards. I put this slide in for a point that I think Hernando County came to me one time and asked that they'd had some students design an anti-spearfishing or a fish safe from spearfishing module. Could we use it? These were the types of things we wanted to see. If you can document it's structurally stable, it'll stay put during the 20-year storm, and it'll be suitable for the fisheries enhancement purpose, the Corps can use it. We would just have to put it out on the public notice for comment. But generally, I have more success negotiating with NIMS if I have these materials in hand when their comments come. This is the kind of the general categories of the permit conditions you're going to see. To protect existing resources, your reef permit may require buffers from existing seagrass beds, for example. We have pre-deployment notification procedures in your permit that you would want to follow. The clearance and assurance of navigation is a big one. Our permits, when they go out, they have a minimum clearance for navigation. Generally speaking, it's 2 times the height of the structure measured from the top of the structure to mean low water. Keith mentioned a couple instances where things sunk prematurely or we didn't hit the nav clearances, and you've either had to move them or chop them into pieces to get the nav clearance. So that's a bad day for everybody involved. Post-deployment accuracy is a big deal. When you submit your as-builts based on your special conditions, things are getting a lot easier with the side scan sonar and the efforts that University of South Florida and FWC is going to help counties and to map these things out. But that's something to keep in mind, that we want to know where you put it. So keep track of it when you put it out. Your next suite of conditions is generally related to endangered species protection. There's a document called JaxBO that Keith touched on. I'll go into a little more detail about. The thing to remember about that is JaxBO can severely curtail the time you spend in the permitting process. And then we've talked about ownership and liability. There is a special condition in our permits that attributes ownership and liability to the applicant, and it would be the applicant's primary responsibility to fix any foul-ups that occur. JaxBO is basically a programmatic consultation document that the Corps generated along with National Marine Fisheries Service Protected Resource Division for a way of addressing requirements under Section 7 of the Endangered Species Act. Essentially, Section 7 of the Endangered Species Act requires that before a federal license is issued or a federal action is taken, it says that a consultation must occur with Fish and Wildlife Service or National Marine Fisheries Service so that the proposed action won't jeopardize the continued existence of an endangered species or adversely modify their designated critical habitat. It used to do an individual Section 7 consultation with NIMS used to take months, perhaps even into a year or more. The miracle of JaxBO is that it shrunk this process down to potentially a matter of minutes. If I get a complete application that demonstrates that the proposed project would meet these PDCs, which stands for Project Design Criteria, that JaxBO lays out for artificial reef deployments, I can make a unilateral decision that the consultation is complete and move out. I don't need to wait for go ahead from NIMS, in the sense that I already have it in my hands in the form of JaxBO. JaxBO covers a suite of activities in Jacksonville District, not just artificial reefs. These are those. Activity 7 for aquatic habitat enhancement. That includes the criteria for artificial reef deployments. I'm not going to go into it today in a great amount of detail. I don't have time. The most important thing you know is this document exists. And when you plan your artificial reef projects, do everything you can to meet the project design criteria laid out in JaxBO. Even, for example, so if you need a bigger area for reef deployment, if you can meet every other criteria, do so, because it makes our jobs a lot easier to present to NIMS that your endangered species concerns are addressed, but for the size of the deployment area. And generally speaking, then the conservation recommendations that come back are be consistent with JaxBO. And we do have some ability to use the JaxBO process for non-conforming projects. So if there's minor deviations in your project, we could generally accommodate them. But this is certainly something you want to be aware of and plan JaxBO to the greatest extent you can into your artificial reef deployment design. Here's some examples of the special conditions that would come along on your permit as a result of JaxBO. Here again, there's an emphasis on appropriate reef materials. the dimensions that JaxBO provides are actually incorrect. 1/4 nautical mile by 1/4 nautical mile is not 40 acres, it's actually 53. But I cleared it up with NIMS. They actually meant 53 acres, not 40. You'll see that there's a special condition for pre-deployment benthic assessment. You would have to verify that you're deploying the material not on existing resources. The one thing that JaxBO added that is new and potentially onerous is the cleaning of reef deployments on a cyclical basis, cleaning it of monofilament and what have you, and making sure that the reef site is maintained in the condition that we intended it to be permitted. Another set of conditions that's new is based on some research Mike Barnett and NIMS did, that sea turtles tend to get trapped in some of the modules. So there's some new criteria for modules, I guess, to essentially we would say make them turtle safe. These are things that NIMS is holding us to in the permit review. Activity 9 of JaxBO is where you would find the criteria for the cleanup that's required under these special conditions. Some more examples of the permit conditions would be the initial agency notification to us and the Coast Guard. The reef parameters are going to be in your permit. How deep can it be? How heavy the materials must be? Pre-deployment notification, documentation, the post-deployment report. Really, I tried to put this presentation together so that you have something to take home with you to read over, so that in the event that you were preparing an application or planning a reef, you would have it. I think one of the big take-home messages I want to put out there is once you get your core permit, your responsibilities don't end. What I've seen is I've gotten reef applications in the past, for example, that there's a previously permitted deployment site that's not full. At the 10-year per work window that the initial permit provided, the deployments, sufficient deployments didn't occur, I guess, to fill the reef area. The county then comes in to reauthorize deployments in that reef area. One of the first things the Corps is required to do under our regulations is go back and determine if you're in compliance with your existing permit. If I can't do that, or our enforcement and compliance staff can't do that, I can't review the application on my desk until that process is done. So one of the things that you can really do to curtail the length of time that a reef permit would stay in the Corps' hands is if you're asking for a reauthorization of deployment into an existing reef, or to expand the size of an existing reef, or modify an existing permit, have good documentation and records of your required compliance measures. At that point, once we can show compliance, I can review the new application. Just a little bit of information is that then NEFA, the National Fisheries Enhancement Act, did allow for some penalties for unauthorized deployments or inappropriate deployments. We generally process those the same as we would for Clean Water Act violations. And essentially, if you make a mistake with a deployment, it needs to be charted and it needs to be addressed. If it doesn't need to be pulled out, we at least need to make sure it's appropriately charted to resolve the compliance issue. So if something happens, be proactive about reaching out to the Corps so that we can address it. And this is just a general summary. Our applicants are normally government entities. The proper siting of the reef is vital to success in really minimizing the permit touch time with the Corps, or the review time. Make sure your materials are suitable and in compliance with JaxBO and the documentation that's available. Prevent unreasonable obstructions to navigation. We don't want these in fairways. We don't want these in shipping channels. You know, NOAA Oceans Survey, they get a little sideways when those issues arise. So that's something that you may want to reach out to them in a pre-application process to make sure that your siting is good. Your compliance with this JaxBO document severely would reduce the review time that we've seen in the past. And deal with your uncharted deployments quickly. JaxBO and what have you is available on our website. Here's some brief information about application submission. The core, almost entirely in Jacksonville District, has gone to an e-file system. The two email addresses you see there are for Tampa permit section and Panama City permit section. Those are probably the two sections that you're going to deal with most often, given the audience we have here today. The general rule of thumb is the northern counties that are west of the Suwannee River, they're going to Panama City. If you're east, you're coming to Tampa, or basically me in Gainesville. There's some additional links we have to our regulatory process and some videos about completing a basic Section 10 application. This gives you a breakdown of the counties that each section, Panama or Tampa, would be responsible for, and some references, and my contact information is on the first slide, but I think I have a minute or two for some questions.
Two questions from the online participants. The first was, can you please clarify how you would go about modifying an artificial reef permit if the opportunity to sink a vessel would arise?
The easiest way to do it would be to initiate the process by submitting the Corps' application form. It's called an ENG 4350. Basically, that would give us the basic information we would need. Then you would want to go ahead and give the information about the compliance with the EPA and Coast Guard regs about the vessel deployment. And as soon as those criteria were satisfied, we could go ahead and begin modifying the permit. And if the vessel deployment required that the reef coordinates be expanded, we'd also want to know what the new proposed coordinates were so that we could coordinate those with NOAA.
Thank you. And the other was, can you give an example or describe a turtle safe versus a turtle non-safe one?
Essentially, the best place to look for that is in the JaxBO opinion itself, or the document. I have some here. I'll have to find them in the small print. Three-sided modules where each side of the top opening is at least 36 inches in length. Basically, you want to have designed a module that is very difficult for a turtle to get trapped underneath it or inside it. In the JaxBO Activity 7, it goes into very specific detail for each module. And the person can always contact me if they need to kind of go through those materials. Go ahead, Will.
I understand that it was a recommendation from you to help stimulate their master planning. If that's the case, can you elaborate the rationale?
Sure. Several years ago, a bunch of folks from Hernando County, I might say, invaded my office. There was a bunch of them. And they came in and they said, what is the deal with getting a core permit for an artificial reef? Took me quite a long time to get the reauthorization for Ben Dixon, which was originally authorized in the early 90s, off of my desk. The primary reason for the tie-up with the initial Ben Dixon application was National Marine Fisheries Service Endangered Species Review. We didn't have JaxBO, so it took about a year for me to get a biological opinion for them from NIMS to move that forward. But one of the things that we talked about is that when it comes down to artificial reef siting, there's requirements in our regulations and the National Fisheries Enhancement Act that say that your artificial reef deployments should have a fisheries enhancement purpose. You should have target species in mind, and you should paint a clear picture for the resource agencies what you're attempting to do with your artificial reef. And that's something that everyone should bear in mind when you submit the applications. I want to see target species, what you're trying to do with the reef to present to the other resource agencies. But what I had suggested to Hernando County is that if you had some pre-planning that went into identifying potential artificial reef sites and habitat needs or fisheries enhancement goals for each area, if you would present those to the Corps along with your application for a deployment, I would get a systematic, clear picture of what your reef program looked like. And when that happens, it makes it very easy for me to compare what you're proposing to do with the National Artificial Reef Plan. And it makes it very easy for me to, the heart of the Corps review for Section 10 of the Rivers and Harbors Act is called the Public Interest Review. And essentially what the Corps has is about 20, 25 criteria, such as economics, navigation, environmental concerns. We go through all these criteria, and at the end of the day, the balance of the criteria has to demonstrate that the proposed action is not contrary to the public interest. When Hernando County came to me, I said, look, if you already had your economic studies in place, you already had your environmental and your fisheries enhancement needs in place, you already had your areas identified that would appropriately address navigation concerns, my job in the public interest review is done, right? I have the document I need to pull from or the understanding I need to make a quick permit decision, and it serves as a long-term planning tool for the county. Basically, it gets the Corps and the county speaking the same language. Some very good resources I've seen counties use over the years is Fort Sea Grant, the conservation clinic at the law school. You know, it's really interesting to see how many resources we have in this area that can help you pull these things together. And once we're all speaking the same language and we have appropriate documentation, all of our jobs get that much easier.